confinement and forcible strip searching of children in prisons, secure training centres and local authority secure children's homes. So 5 years has passed since that report. As you know, there have been various events since then, but one could hardly say that progress on these issues has been pell-mell. It was therefore decided by the Howard League, with my agreement, that we should hold an evidential hearing on restraint, first of all today, and then on Monday the 6th of June at 5 till 7 p.m. in room 4 on this corridor. I should say to you that today's proceedings are being recorded, voice recorded, and the evidence is going to appear, or has appeared already in part, on the Howard League website. We have 4 evidence sessions today. You will have to forgive me if at some points I disappear for 2 reasons. One is because there will be, I think, some divisions in the House of Lords in which I must vote. Also, when we get to Amendment 8 and 10 on the bill that's being discussed on the red screens at the moment, they are my amendments, and it's just a misfortune that the days have coincided. However, they may not be reached until after 6:30. But when we get to Amendments 6 and 40, which you will see on the screen, I will have to disappear because I think the next amendment, Amendment 7, will take very little time. In that period, if it arises, Francis Crook, the director of the Howard League, has agreed to take the chair, and we have discussed the issues which will arise in that context. Right, so now let's get on with it. I'm deeply grateful, and so is the Howard League, for those who have provided evidence. And it is notable that we've had a great deal of cooperation for this hearing, not least from Crispin Blunt, Minister of the Ministry of Justice, John Drew, Chief Executive of the Youth Justice Board, Sue Berlovitz, the Office of the Children's Commissioner, and also from Cray. Carolyn Willow was involved in the production of the 2006 report, and she will be giving evidence. We're going to start the evidence session with evidence from the Howard League. Laura James is the Solicitor for Children at the Howard League and head of the children's legal team. She'll forgive me for saying that I know she's very clever and very articulate. Indeed, she's articulate about almost anything you care to mention. And she is currently doing a doctorate in relation to youth justice. She is, I believe, the practicing expert on these issues, despite her youth. And therefore it's a pleasure to invite Laura to give evidence. Laura James, welcome.
Thank you very much. If I may just provide a short summary to start with of the things that have really struck me over the past 5 years as practicing as a solicitor at the Howard League for Penal Reform, where I'm exclusively representing children who are detained. So my evidence is really based on what children have told me, both in terms of cases where they are bringing complaints about restraint, but also where I'm representing them on other matters that issues of restraint have come up. As you know, lawyers at the Howard League also fulfill a wider policy role, so some of my evidence is based on just talking to children as part of that role. Reflecting in advance of today's session on the things that really have struck me over the last 5 years is that I have never, during that time, received a complaint from a child about being restrained in a secure children's home. I have had plenty of clients who have been restrained in secure children's homes, but none who have felt that it has been done unfairly or in a bad way. However, unfortunately, I cannot say the same for restraints that take place in secure training centres and YOIs. A further point that has really struck me is the frequency with which restraints may take place, despite the very strictly prescribed circumstances in which restraint can be lawfully used. I have had clients who have been restrained. One child client was restrained up to 5 times a day over a certain period. The overwhelming sense of powerlessness that my child clients describe to me during these situations, often saying that they just see no point in complaining, that they feel they've been stitched up. And I have to say that as a lawyer acting on their behalf, I have not once in my 5 years of practice actually received an apology or an upholding of a complaint in relation to restraint, even though there have been several examples of broken bones and clear excessive use of force. A further point that has really struck me is this damaging culture of violence that seems to be pervasive for many young people in secure training centres and YOIs, which of course runs completely counter to the aim of the youth justice system, which is preventative. Lots of children have talked to me about feeling cooped up and frustrated, so that by the time they eventually are out on association or movements, that tensions are so high that violence comes more easily. Which leads on to another concern, that violence does appear still to be routinely used to manage behaviour, and that threats of violence by staff seem to be given if children do not comply, which we know the courts have said is not appropriate. So despite very clear guidance about what techniques can be used, lots of children are still complaining to me about the use of unauthorised force, which they describe quite simply to me as being pushed about, which of course none of us like, and which is clearly does fall into use of force. And finally, the point that really strikes me is a combination of very poor follow-up care, the breach of trust that results from physical intervention, excessive physical intervention, and the power imbalance, where children talk to me about being jumped on by fully grown men, make this entire experience a real affront to children's sense of dignity and self-worth, which are of course key factors in terms of risk of reoffending. So I'm happy to elaborate on any of those points further, but that's
Thank you for that introduction. The way we're going to run these evidence sessions is that I shall act as it were, interlocutor or inquisitor. But I will ask if anybody wishes to have something put through me to a witness, please would you raise your hand and indicate. But before you raise your hand, can you make sure that it's a nice, short, pithy question, and that you're willing to identify yourself and the organisation, if any, that you represent. So if anybody wants to do that, in due course, please will you raise your hand during the next